Good afternoon, and welcome to the Quarles and Brady Business Law Training Session titled, We're Not in Kansas Anymore, What to Do When a Union Tries to Organize Your Company and You Land in Oz. I'm Kim Mahan, a partner in the Business Law Group here in Chicago. Before we begin today's presentation, we would like to invite you to join us on March 14th for next month's program on what every company needs to know about political compliance. As always, we have a few housekeeping items to review. For CLE credit, for our in-person guests, please fill out the CLE sign-in sheet located at the registration table before you leave today. For our webinar guests, please email the CLE form located at the back of the PDF materials to Sarah Rebessa, whose contact information is on the form. If you are listening via webinar and have a question, please type your question into the question box on the upper right side of the screen and press send. The conference host will make sure the speaker receives the message. Also, for our webinar participants, we have muted all phone lines and participants are in a listen-only mode. A survey will be emailed to you after the program. Please be aware that this presentation is being recorded. And now I would like to introduce today's speakers. Judy Williams chairs the firm's Labor and Employment Group's National Labor Relations Act team. Judy's practice focuses on helping companies with various union issues, including organizing campaigns, union elections, unfair labor practices, and bargaining contracts. She represents management in federal and state litigation and before administrative agencies, counseling employers on various employment-related issues, investigating complaints made by former and current employees, and representing employers who are litigating whistleblower claims. Fred Gantz is a member of the firm's Labor and Employment Practice Group. As a management lawyer, Fred represents companies in a variety of matters, including defense of discrimination complaints, employer counseling, traditional labor, including collective bargaining and unfair practice charges, and representation on OSHA matters and citations. Fred has represented employers in courts and before state and federal agencies, including the National Labor Relations Board and Occupational Safety and Health Administration across the country. And now I'll turn it over to Judy.
Thanks, Kim. We're here on Valentine's Day to talk about a topic that Fred and I love, unions. I think that Fred would actually say they're the bane of his existence sometimes, but they're always interesting. And the good news is that, generally, unions are uncharted territory. The majority of employers in the United States are not unionized, but the fact of the matter is that any employer is susceptible to being unionized at any moment. And so it's really important that you have an understanding of that uncharted territory of a union trying to organize your workplace. So today, is that not advancing? Oh, we have an issue with the slides internally, so hold on one second. There we go. So the big ta-da, we're going to talk about goals, what we're going to do today. The slide that did not want to show. The first thing we're going to talk about, and we're going to spend a fairly large amount of time on it, is what to do to avoid having to deal with a union in the first place. And it's really important, if you can, to not have to deal with a union, because we're going to talk about the disadvantages that you have in the workplace, and there are some serious consequences of having to deal with a union. And then we're going to go on to talk about what to do if a union is beginning to organize and you're aware that you are now in that zone of being on the union's radar, and what you can do to try to still maintain your non-union status. And then finally, we're going to conclude talking about some things to help you do if you become or are unionized either after a union campaign or if you're current unionized employers. These would also apply. And it has to do with bargaining and what you can do in bargaining to obtain your objectives. So, what are those drawbacks to having a unionized environment? Well, if you're not unionized and you have a policy and you want to change it, you can go ahead and change it. It's great, right? I decide this is not what is working for me. All I have to do is change my employee handbook. That is not the case when you are unionized. When you're unionized, you have a contract with a union, and that contract sets forth what you can and can't do. If any of you are familiar with an employment agreement with a high-level executive, that's a situation where you have an agreement with somebody and it talks about what they're going to get paid, what they're going to do, what their duties are, and you can't change those agreements without amending them. In the union situation, it's similar. You have an agreement, and that agreement governs everybody in the bargaining unit, not just one person as you would have with an executive. And you have to follow that agreement. Even if it's something that's not covered in the agreement, if it's a term and condition of employment, you may have an obligation before you change that term and condition of employment to actually bargain with the union over it. So one of the big things that you lose really is flexibility. What does that mean? Well, so right now, if you've got a non-unionized workplace, maybe you assign individuals work based upon their ability. Who's the best at doing this? In a unionized setting, you may have a collective bargaining agreement or a contract which says that individuals are assigned work not based upon who's the best at it, but based upon seniority. That's a pretty big limitation on your operations. You lose flexibility in schedules. CBA most likely will have, and that's a collective bargaining agreement, most likely will have some sort of shift schedule or reference to how many hours are normally worked in a workday. Or even if you don't have it in the agreement, you will probably have a practice about what your schedules are. When you have that situation, you cannot change the schedules without once again going to the union. So if you decide it makes more sense to start at 6 instead of 7, you can't simply make that change. You also lose the opportunity to work out individual problems, and that's because once you have a union, the union represents your employees, and you need to talk with them about any changes in their employment. If you talk directly with the employees about changes, that's called direct dealing, and it violates the National Labor Relations Act. You also lose, because of that third party in between you now, person-to-person relationships. You can't negotiate with employees over, like I said, their work hours. You must comply with what the CBA says unless the union agrees otherwise. And then I think one of the most important limitations when you have a union is what you can do about pay and promotions. In most non-unionized workplaces, pay is determined based upon how well you do, how good of a performer you are. We get into a union setting, in most situations, the union wants you to agree that you're going to pay everybody the same, no matter how good they're doing, no matter how bad they're doing. And they want you to promote based upon seniority, not based upon who might be the best qualified person for a position. So if you're running a business, those are pretty significant limitations on what you can do, right? Now, employees also may lose. We just talked about the pay issue. So if I'm a great employee, I may on average be getting a 4% increase. An employer is probably not going to agree to a 4% increase for everybody during bargaining. They're probably going to look more at the average of what they've been given previously. And so you're probably going to see an actual decrease in raises that you've been receiving. And think about the effect of that. If I'm a great employee and I'm now receiving the same amount of raise as somebody who's not a great employee, what motivation do I have to be a great employee at that point? So that's one consequence for the employer that also affects the employee. If you're in a state that's not right to work, you as an employee may be required to join the union as a condition of employment. And then you have to pay the union dues, initiation fees, so it can cost you money to be represented by a union. Now, in some states, I think 27 or 28 right now, it's a right to work state. That's Wisconsin, where you cannot as an employer agree to that with a union. But Illinois and Minnesota are examples where that can occur, and employees may, in fact, have to pay money to be represented by the union. The employees, once again, lose personal relationships with supervisors. They learn the ability to be able to go easily into other positions and learn new skills. They lose the ability to have personal considerations come into play. Maybe I'm an individual who's got a child care situation, and I would like to start work 30 minutes later than everybody else. And maybe operationally that works, but now there's a collective bargaining agreement and it says that I as the employer have to comply with that shift schedule. I can't make a change. So it can in fact hurt employees as well. Okay, why would your employees want to organize? Why would they want to have a union come in if there are these drawbacks that I just mentioned? Well, they might feel like they need a third party in the relationship. And why would they feel like that? Well, one reason could be a lack of communication. I feel like I don't have any say in the company. My thoughts are not heard. People don't listen to me. I don't know what's going on. I'm not told that this is our goal for the year. I sort of feel like I'm coming to work and nobody really talks to me about what we're doing or why we're doing it. Or they're the last to know about everything. They feel like they're not respected because they don't know what's going on and people don't feel like they should know. Favoritism and discrimination. I don't feel like I'm being treated fairly. I need a third party to come in here and help me so that I am being treated the same as everybody else. I don't think I'm going to have a job in the next few years. I think maybe the company's going to start subcontracting work, or they're hiring all these temporary employees, and maybe that's because they want to get rid of regular employees. Non-competitive wages, benefits, and working conditions are a big issue that can lead to organizing. If you are way below in a market analysis of your competitors, that should be a concern. Especially now in a hiring environment, your employees are being made aware of what other employers are paying. And so as these new employees come in, they're aware of, hey, maybe I could get more if I went to another employer. And that might be a reason why they think they need to have somebody come in and help them get the employer to pay more money. A big one, and one that I think oftentimes employers don't realize until it's too late, is a boss. I have had a number of union organizing campaigns that were based upon one supervisor who the employees felt didn't care about them, didn't listen to them, always picked on them, and the company was aware of it, but they didn't do anything. They're like, well, it's just the employees. They don't want to work. But if you are repeatedly getting complaints about the same individual, that is a concern, and that leads employees to think they need help from the outside if you're not doing anything about it. Not understanding those drawbacks that we just talked about is another reason why organizing occurs. They'll have somebody call them and tell them they can get them all these great things and not realize that there are the drawbacks that I just mentioned. And then personal frustrations, not having a belief that the company understands, the individual. So these things lead to some of the typical organizing issues that we see, things that unions will point to when they're trying to get individuals interested in organizing. A lot of times they'll point to economics and how they can help individuals economically. They'll point to the poor communications and indicate that once they're in place, the company has to talk with them. They have to bargain with them before they make changes. They'll point to job security, staffing issues, seniority, decisions being made based upon how long you've been at the company instead of the discretion of the company, what it decides is most important. So the warning signs, and these are things where if you see these happening, it's really important that you think about what it might mean and the consequences and that you address them. Because once these start to occur, it's more likely that you're going to see employees thinking that they need to have that third-party union involved. So if you see an increase in employee complaints, you have never had a complaint ever, and then all of a sudden in 6 months you've got 20 complaints, that might be an indication that something's going on, especially if it's the same individual that everybody is complaining about. Employees who don't normally associate with each other. And it's really funny because I've had a couple of times now during campaigns where individuals have said, I should have known something was going on. And it's because, John and Mike have never gotten along. They've disciplined them about fighting with one another and arguing. And then all of a sudden, every day at lunch, they are sitting together in the back of the cafeteria talking. And then they stop talking as soon as somebody approaches. Those are signs that if people don't normally associate and all of a sudden they are associated, why is that occurring? Avoiding supervisors. Supervisors used to have great relationships with the employees, and now as soon as the supervisor approaches a conversation, everybody stops talking. That might be a sign that there's a problem. You actually see employees distributing materials or cards, or you'll find a flyer about unions in the break room. The cards we're talking about are authorization cards, and Fred's going to talk a little bit about those, but they're cards that employees sign indicating that they want the union to represent them. And once the union has enough of those cards, it can actually get an election of the employees, and that's when you're into the union campaigns that Fred's going to talk about. Also seeing blogs that are hostile towards the employer. All of a sudden, everybody is in social media, and you're hearing about these comments being made and people not having great positivity about the workplace. Argumentative questions and challenges. You're having your department meetings, and instead of individuals being willing to listen and see what you have to say, they're disputing everything that you're saying, or they're challenging why you're doing things. And then the big one, an unusual number of inquiries on policies, particularly relating to benefits and discipline. Individuals usually get an employment handbook at the beginning of their employment, and then they put it away, and most of them never look at it ever again until a new one is handed out. And if all of a sudden people are really interested in your employee handbook, that should be a warning sign, because that's one of the things that a union wants to look at. They want to see what your policies are and what policies they might be able to use as leverage to convince employees that they need to have a third party representing them. Okay, we also want to talk a little bit about some trends, because these are some things that I hear, and I want you to not get caught in the trap. So one comment I hear sometimes when I raise these issues with my clients and concerns about, is there a union may be interested in your workplace? Union? Those things are extinct. They went the way of the dinosaur. What are you talking about? It's true. I mean, unions are not at the height of their membership that they were, 20, 30 years ago, but they still exist. And they have been energized, and they are willing to spend lots of money to organize a workplace if they think they have a chance of getting into the workplace. And the reason for that is, even though you may be in a right to work state, they know that at least some of those employees are going to pay union dues, which means money in their coffers. So they are very interested still in organizing if they can. And under the Obama administration, the National Labor Relations Board did a number of things to try to make it easier for them. And Fred's going to talk about a few of those items. But they're much more aggressive as well. It used to be that unions would wait for an employee to come to them. Now they cold call employees. If they hear about some issue in the news at a company, they're trying to find people at that company, and they're calling them to say, hey, maybe you need a union helping you. So they're much more aggressive in trying to get people to organize. They will handbill at your property, which means they'll hand out information about why you're a terrible employer. That's supposed to be done on public rights of way and not on your property itself, but they will show up. I've had sometimes I'm showing up at the president's house of a company trying to get them embarrassed and humiliated in front of their neighbors. They will try to help employees accuse the employer of discrimination and file complaints against them to try to show why it's necessary to have the union representing employees. So they are very aggressive. And there are things that you can do to counteract some of these items. One is an employee relations audit. I know a lot of employers look at their handbooks fairly frequently, but I really encourage a comprehensive audit, once a year. And if you're getting a lot of complaints, even more than that, where you're looking at all of your policies, you're looking at your supervisors. Are we having any issues here, hearing about any complaints where we think we could improve? And that might mean making a slight tweak to a policy, which still allows you to operate operationally, but you know that you'll be able to make your employees happy and less likely to think they need somebody listening to them. Surveying your property, that seems like a no-brainer, but when you have people hand-billing and they're at your property and the question is, okay, where is the property line? The police don't want to get involved. They're not going to be trying to figure out, okay, your property line starts here and it ends here. They're not going to go down to the city office and get a plat of your property. But if you have that and you can show the police, hey, they're on my property, you're much more likely to get them thrown off for trespassing. And then just being proactive, having a good public relations consultant that you can go to if you start to see negative campaigning is really helpful. Somebody you're comfortable with that will be able to help you develop an image to counteract any sort of negative social media. So the next trend that I want to talk about, because I think it's something that I also hear quite a bit, is I'm not a manufacturing company, so why should I care about unions? And that it is true. There's a lot of union activity in manufacturing, but if you are an employee, you could be organized. There are limits. Supervisors are one type of employee that cannot be organized, but really any industry can be organized. And we've seen an increase in healthcare, in the services industry, in IT individuals, in graduate students. So really any industry can be organized, and you shouldn't think just because I'm not in manufacturing that this is not a concern. Now, another successful tool that we have seen, especially with the Me Too movement, is focusing on specific types of employees, specifically women and minorities. And if a company has a reputation for having a lot of sexual harassment, if they're in the news for a sexual harassment claim, unions are focusing on the women at the company and trying to get them to understand the benefits of having a union representative there to help them. So in order to counteract that perception and that trend, it's important that you are looking at your various areas of your workforce. If you have a large company and 25% of your workforce is in the call centers, so that it might be easy to organize those individuals, and they're a large group that the union thinks would be attractive to them. You want to be thinking about, am I having issues in those types of areas? You want to conduct training on a periodic basis for supervisors and managers. So I told you about those warning signs a few slides ago, right? If you're in upper management, you may not know about any of those things. You might have supervisors right now who've seen a flyer in the break room about a union, but they don't know that's a warning sign. So you have to educate them because they're dealing with the employees. They're seeing these things. They're seeing Mike and Joe all of a sudden being friends and people not talking openly with them. So you want to make sure they're aware of the warning signs. And also, Fred's going to talk about some things that you have to do and that you want to avoid when a union is in play. And it's important that they know about those because if they violate those rules, you can have an unfair labor practice charge, which could affect a union election. And then finally, communication mechanisms. Once again, going back to our earlier slides, communication is so important. And employees really want to feel like they are a member of a team, not that it's them against us. And if you can encourage communication so that individuals are feeling like they don't need a third party to be heard, that will be really important. There are things that you can do to maintain open communications, some of which are really easy. You can have department or shift meetings so that people are aware of what's going on in the department. A state of the organization meeting, these are good at the end of the year or the beginning of the year. You're talking about this is what happened last year, and these are our goals for this year. Employees will feel like they're involved, like management is not hiding things from them. Another thing that's really good is a management walk around. I'm not sure how many of you have ever done this, but it's just so empowering for an employee when the president of the company comes up to you and says, how are you doing? That they know your name, right? And they're saying, anything going on, any issues? If you have that type of a relationship with your employees where they feel like people know who they are and are listening to them, it's going to be really helpful in deterring organizational efforts. Newsletters are great, suggestion systems. Another thing that we have seen, I think works effectively is employee committees and employees being able to give feedback. In most instances, they're the ones who are actually doing the services or the production that really make the company run and profitable. And you can form committees where they're helping you by giving their input. Now, I want to have a cautionary note here. You can go too far in forming committees. Under the National Labor Relations Act, an employer cannot unlawfully sponsor or dominate a labor organization. And so, interestingly enough, if you decide I'm going to form a committee and I'm going to form it based upon an election of representatives, and then you give that committee the power to make decisions with the company, that can be a problem. As a practical matter, there are committees that are okay, and we've listed a couple of them here. Regular gathering of employees to address concerns, like an ad hoc committee because you're seeing an issue in your safety area, that's fine. The plant meetings that we've been talking about, those are not committees that are going to get you into trouble. Quality circles where you're having work teams deal with the production process. Maybe you're seeing an engineering issue, and so you form a work team of individuals who are working on the product to see what they're observing and try to ask them what they think maybe will fix a problem. That would be okay. And then the suggestion programs that we just talked about where you have maybe a suggestion box or you sit down with employees and say, we want to hear your thoughts on this issue. Do you have any suggestions on how to fix it? Those would be okay. Oh, now I'm going to turn it over to Fred, and he's going to talk about another trend that we've seen, which relates to handbooks.
Well, good morning. And I should say, I guess, good afternoon and happy Valentine's Day. We're working on the tough love portion of your day and hope it gets better. But with all of that, there has been there always is, with every presidential election, when there's a change from a Democratic to a Republican president or vice versa, the National Labor Relations Board gradually changes as the appointments are made. And so when Barack Obama was president, the National Labor Relations Board took probably the most aggressive view of handbook violations in my career. And that is no longer the case. We're seeing a much more balanced approach in the Trump administration with respect to employee handbook provisions. So you have a rule that when you have a rule, the Obama administration's National Labor Relations Board had taken the position that many of these rules could impact the nature and extent of the potential impact on National Labor Relations Act rights, which are primarily protected concerted activity. We'll talk a little bit more about what exactly that means. And now we're into a much more pro-employer board with respect to employee handbooks. So there's a general counsel memo that contains a new guidance for NLRB regional offices as they're considering unfair labor practice charges. And I'll explain this further in another slide shortly. So one of the things that we think is important about your employee handbook, you got to look at it from a standpoint of it's doing various things for your employees. It's informing employees of their benefits and work conditions, but it's also providing employers with an opportunities to make clear their expectations, including work rules and discipline. So I've always had the view that a good employee handbook is a strong argument for non-union employers to not have a labor agreement with a union. This employee handbook gives you very many things such that you don't need a third party, you don't need a labor union here, you don't need a labor agreement. So whether you are not unionized, whether you are concerned about potential union activity, or whether you have been unionized for many years, and we have many successful companies that we represent that have that latter situation, where they are already unionized and they're still very successful companies. There are things that I think are naturally associated with an employee handbook, that at the beginning of the employee handbook, you want to make clear this is at-will employment. This is a book for guidance. It's not a contract. We have a policy here of equal opportunity and prohibition of harassment. I suspect that most of you have those provisions in your employee handbooks already. But there are a number of rules that are listed in this slide that have to do with some things you may not have thought about before, such as civility rules or disruptive behavior rules. So these are areas that previously the Obama National Labor Relations Board had raised a lot of questions about. And they said, this could interfere with employees' protected and concerted activity. What is protected and concerted activity? It's the right of employees to talk about their wages, benefits, and conditions of employment. And so now you have the NLRB coming out and saying there are a number of rules in this area that you can legitimately put into your employee handbook, and we're going to regard them as generally lawful. So for example, we've heard a lot about Mr. Michael Cohen and recording. We are in Wisconsin a one consent state. If you have employees who want to record conversations with you as an employer, they have the right to do that. If you put in your employee handbook that we have no recording rules here, we want an environment in which we're not going to record your conversations, and our expectation is that you won't record ours. That's now a provision you can put into your employee handbook that's going to be regarded as generally lawful. So if you look at this slide, you'll see a number of areas that you may not have in your employee handbook and that you may want to have. On the other hand, you perhaps could come to a conclusion that I'm not worried about what I say with my employees. I don't need a no recording rule. But we want you to be aware of these opportunities that are out there and that are expanded in a Republican administration now. Now, there are some potential issues with handbooks. One of the ones that's been around for many years has to do with non-solicitation rules. I'm going to talk about wage discussions. I'm also going to talk about dress code. if you have a non-solicitation rule that is overly broad, it's going to be illegal. And I'll talk about some ways in which that non-solicitation rule can be overly broad. The flip side is that if you have a non-solicitation rule that is regularly ignored, it's not going to help you if a union comes along and suddenly wants to solicit employees at the entrance to your property or on your property, and you weren't enforcing your non-solicitation rule. So what are some of the things that, and I would say that every employee handbook should have a good non-solicitation rule in it. It has to be properly drafted and consistently enforced. You can ban all solicitation during working time. That's when employees are actually doing their work. Now, you have to be careful that you don't use the phrase working hours, because if you use that phrase, it includes breaks and lunch times, which is not permissible. You also can, prohibit the distribution of literature during working time and at any time in work areas. Again, what are not work areas? Well, break rooms, parking lots, locker rooms, and cafeterias are not going to be regarded as work areas. But if you have a lawful rule, that can be very important. And you might say, gee, it's this time of the year for Girl Scout cookies. What about Girl Scout cookies? Girl Scout cookies are okay because if you've drafted your rule right, donations for charitable purposes or community activities are fine. You can either provide that they're fine upon approval of the company or they're just fine in general. So there's a way to work through that. You don't have to tell some of your employees that they can't put the chart out for Girl Scout cookies, that they can. There's a way to do that and still have a valid non-solicitation rule. Now, off-duty employees can be prohibited from re-entering the work areas of company premises when they leave, but you have to be careful to not prohibit them from coming back onto their property on their off time. What's the distinction there? Well, we represent a number of clients who have retail stores or supermarkets, for example. You can't say that they can't come back to the property during their off time. They can, but they can't be in work areas. So there's ways to do that. Another one that is surprisingly missed a lot of times is if you threaten employees with discipline for discussing their wage rate, that is a violation of employees' protected concerted activity. So non-managerial, non-supervisory employees have the right to talk about their wages. I always understood, you may remember a fellow named Ross Perot who once ran for president. His company had a policy at one point that there could be no discussion of wages in the workplace. That has long been a violation of, the National Labor Relations Board has long regarded that as a violation. So what's the solution? If you have supervisors, managers, an executive secretary, you can have rules that the wages of other employees are confidential, need to be kept confidential, but you can't prohibit your non-supervisory or non-managerial employees from discussing wages or conditions of employment. A lot of times I've seen situations where a supervisor says, and I'm providing this warning to you, and I don't want this discussed with any other employees. That is a problem. I, in fact, once advised a client, I said, that's a violation of their protected concerted activity. And within about 10 days, the charge had been filed with the National Labor Relations Board. And so that's something that you need to be on the lookout for. Another interesting area is union apparel. We get this question from time to time. Somebody wants to wear a T-shirt in the workplace, if T-shirts are allowed, if that's appropriate for a particular workplace. I love unions, or unions built the middle class. They can wear those things. Now, what's a possible solution? Well, a possible solution might be to require a company uniform. But even with a company uniform, there's this authority that this does not prevent union insignia such as a button, Teamster's button that would be worn on the company uniform. But you just have to deal with what you have to deal with. This is one of those areas where we say a lot of times with respect to union organizing, if only it were so easy, knock, knock, who's there, a union, no thanks. Well, no, it just doesn't quite work that way. Now, one thing that we think is very important, and we frequently talk about that can help you avoid having a union if you're a non-union employer, is to follow what we speak of as the 4 commandments. And that's keeping employees informed of what is expected of them. Secondly, advising employees if they are performing satisfactorily or not. How many times have you been in the situation where you're contemplating the termination of an employee, and we ask if there have been any warnings? No, we've talked about this a few times, but there haven't been any warnings. Third, important to treat all employees fairly. And 4, measure employee performance based on facts. There may be a group of employees who are very close, are good personal friends outside of the workplace. That's fine. But what we care about is that employee performance is going to be based on facts, not opinions or assumptions. So this becomes a very good thing to follow, whether you are or are not unionized, but particularly for the non-union employer. If you're following those commandments, that's going to be a good way to keep the union away. The process of unionization. One of the things that happens is the first thing that a union is going to do is it's going to go to the employees and get them to sign an authorization card. And if they can get 30% of the employees to sign authorization cards, that's regarded as sufficient showing to then bring about an NLRB election. And a lot of times, as a practical matter, the unions won't even file a petition unless they have more than half of your employees having had signed union cards already. And so that's because they assume that once a campaign starts, their support will come down a little bit. But they can literally file a petition with the National Relations Board to represent your employees if they have 30% showing of interest from whatever group of employees is involved. And one thing that used to happen, doesn't happen as much as more, but if anybody ever comes to you and say, I'm really trying to get a union organized here, I can show you the cards, we've got the interest, never look at the cards. Because if you look at the cards, you could have the NLRB inform you that you're going to have an election. You're going to have to recognize the union without even an election. So that has occurred. What happens is the NLRB will direct an election, and then pre-election campaigning begins. We're going to talk about that. Quickie election rules. This is kind of an interesting thing. I'm always kind of fascinated about what changes and what doesn't. Quickie election rules came in during the Obama administration. They were very significant. What happened is the National Labor Relations Board shortened the period in which an election can occur. And so now, if you're looking at things like who's a supervisor and who's not, you can have a hearing on that issue within 7 days of the filing of a petition. So the board has shortened these periods. And what's significant about that? The less time that there is between the filing of a petition and an election, the more likely the union is to win. In my view, one of the things that's been interesting, the unions have been energized in the last 2 to 3 years. We've seen more petitions for election than we have in quite a while, these quickie election rules may be part of the reason. So the NLRB regional director is going to pick an election date that's as soon as practicable. You're going to have a decreased time period between the filing of the petition and the election. What does this amount to? One of the things that we strongly recommend is if you see a situation in your workplace where you think the employees are potentially going to organize, I do recommend that you contact us or your counsel right away. We've had situations where that has occurred. We've gotten consultants involved, been very successful in companies remaining non-union. So it's an important point.
Well, and the other thing to keep in mind there is that when you get that notice of election, you're going to have a very brief time period to respond, and there are going to be issues, some of which Fred are going to talk about right now, where you're going to need help in figuring out, okay, what do we do here? What strategy makes the most sense for us? And some of them are going to be things like deciding who is voting in this election. And one of the big issues is supervisors that Fred's going to talk about.
And this is a really big issue, and we've got it right on the slides. So supervisors are not allowed to vote in an election. But what they are is they are your frontline messengers. So one of the things that you have to consider, and I urge you to consider it now, and if you're non-union, and I hope you never face union effort in your workplace, who are your supervisors? Because there's a real catch-22 that comes up, and it's on the second bullet, the second sub-bullet of the second bullet on this slide. And that is that if you allow individuals who may be supervisors to vote, what happens is you lose the supervisor's help during the campaign. Okay, so now you look at your workplace and say there's 50 employees that the union wants to organize, and you kind of do your own little count as to who you think's sympathetic to the company, who's sympathetic to the union. You might say, oh, well, I've got some people here, but I want them to vote, so I'm going to take the position that some people who are supervisors or not supervisors, because I need those votes. That can be a real problem. You have to kind of make some judgments here about who really are your supervisors. If they're truly supervisors, we're going to talk about how to maybe figure that out, then you want them to serve as your messengers and not vote. On the other hand, if they're more like, and we'll go to the next slide, lead workers and working foremen, here they may not be truly directing lower level employees. They may just be assigning employees. They don't have discretion and independent judgment to administer discipline. So I think a real key rule to look at with respect to supervisors is your employee actually directing employees in a certain way, or are they simply assigning employees work? If it's more in the assignment category, they're probably truly lead workers and working foremen. They may be very eligible to vote in the election. On the other hand, if they are supervisors, you're not going to have them vote in the election, but you're going to have them be your messengers about why unionization is not in their best interest. So another thing that comes up is now we're into the election campaign. The petition's been filed, we're going to have a campaign. We've been through many of these situations. There are some things that become very important in terms of your communications with employees. And one of them is that we have what we call the tips. And these are rules that you have to follow. It's an acronym. You can't threaten employees to discourage union activity. You can't interrogate or question employees about their support for the union. You can't make any promises of a benefit in return for employees not joining the union. And you can't spy on their union activities. Another way to look at this has to do with discrimination. You can't treat employees differently because of their union activity. The microscope is on you. So going down this list, take a look at threats. We don't want threats to discourage union activity. If there are threats that are made during a campaign, either an unfair labor practice charge or an objection to the election can be submitted, and that's problematic. All right, we'll go to the I, interrogation. We don't want you asking employees about how they're thinking about the union or this union campaign that's occurring. However, take a look at the last bullet. Solely listening is okay. You may very well have some employees who come to you and say, I want you to know this, there was a meeting last night, and here's what happened at the meeting. Don't stop them from talking. Just let them talk, listen. This becomes a very difficult area because they may tell, and there's going to be a meeting next week. And you'd be really inclined to say to them, oh, will you go to that meeting next week? You can't do that. You just listen. But, and listening's okay. Promises. This is the flip side of threats. You don't want to threaten them if they are supportive of the union. But on the other hand, if you say, boy, if you don't vote for the union, there's going to be big wage increases, that also is prohibited. And then finally, as we've talked about before, spying does not work. You can't ask employees to spy on union activities. And you don't want to tell any employee that the company knows which employees are members of the union, although you may very well know some of that information. So then we get into what happens on campaign themes. And one of the things that you have to do is you always have to determine the issues. And I will tell you that issues are very unique to these situations. So you may have one employer where pay is a vulnerable issue. You may have another employer where treatment of employees, or that one poisonous supervisor who never answers anybody's questions is your issue. You got to determine the issues and address them. Just like in a political campaign, positive versus negative campaigning is important. You need both. You need to tell the employees about all the advantages you are providing to them as a company, and you also need to tell them about what the pitfalls could be of being represented by a third party such as a union. And the importance of personal contacts is very important. Your supervisors, as we've talked about before, are your first line messengers. They're likely to have very good relationships with your employees. They may have been promoted from the workforce, and they're likely to be able to get very good information for you. During the period of a campaign, we often work with consultants who are on your premises almost on a regular basis. We can assist you with that as well. What are some of the election campaign strategies? Well, at the very beginning, it might be authorization cards. You can tell people, you don't have to fill those cards out just because they're given to you. Don't feel pressure. You can tell them about certain things in the union constitution and bylaws. I like to talk about the fact that promises are cheap, that if you compare wages and benefits, you'll see we're a really good employer. You can talk about strikes and replacements that can occur with a union and are not going to occur without a union. You want to give them details on the election, because in an NLRB election, if you have 100 employees who are going to be voting in an election and only 40 employees vote, the outcome is going to be determined by those 40. You don't need a majority quorum in an NLRB election. So you got to make sure that people who don't want the union will be there to vote against the union. What can you say during an election? You can say a lot. You can actually, we've talked about all you have to be careful about saying, but in this slide and the subsequent one, you'll see that all sorts of things you can say. You can inform the employees that the company prefers to deal directly with them rather than with a union or an outsider. You can inform the employees that they don't have to join the union to keep their job with the company. Now, you might say, oh, but Wisconsin's become a right-to-work state. They don't have to join the union anymore. One of the things we've seen in Wisconsin since it became a right-to-work state is the unions are sending employees messages about, particularly ones recently hired, about here's what you need to fill out. This is a unionized employer. And we've been involved in efforts where we have to either work with the union or tell the union, look, if you send that kind of a letter, we're going to tell them you're being very misleading. You're implying that they have to join the union when in fact they don't. So these are things that you need to let employees know about. And you can remind them that the union is a business and unions do not provide job security. One of the great ironies that we have in Madison is when I came to Madison, the largest employer was Oscar Mayer. And it has a union bar and facility right in its parking lot with a big sign about how unions provide job security. And now, what was formerly one of the biggest employers in Madison is not an employer anymore in Madison. So unions provide no more job security than a good employer can provide. And you got to make sure that employees know about that. Now, Judy's going to speak with you about what happens when that election is done.
Well, when it's done, hopefully you've won, but sometimes you lose. The election, the votes are actually counted by a board agent after the election is concluded. And what you can do depends upon what happens. If you win, great. If you lose, you have an option to appeal, and so does the union. And that's really what's called objections, filing objections. Ultimately, the union is not representing your employees until it's certified by the National Labor Relations Board. So when you win, congratulations, the union's gone. You never have to deal with them again. Not so fast. So it's great that you've won, but there is not a bar on the union ever organizing your employees in the future. Especially if there's been a small margin, you should anticipate that you might see more organizing activity. And usually the activity is still going on even during the 1 year bar. So there is a 1 year bar. For that 1 year after the election, you have a honeymoon. You don't have to worry about an actual petition being filed, but your employees still know who those union organizers are, and you can believe that they're checking in on the employees to see what's going on. So all the things that we were just talking about at the beginning that I spoke about relating to warning signs, you still need to be worried about those. If you found out that there was something that was creating problems for employees, now's the time to deal with it. And you should also expect that the union is going to file objections, especially in a close case. If you lose, you also have the ability to file objections, and this slide talks a little bit about what you need to do. Ultimately, you need to file a written statement and an offer of proof, and that is a big thing to be thinking about even during the election. The offer of proof has to be filed within 7 days of the vote count, or the notice of the vote count, and you have to identify who your witnesses are and the specific testimony that they would provide. So when you are going through an election, if you see things that are problems, that you think the union is crossing the line and essentially changing the laboratory conditions is what the board calls it, where there's an atmosphere free of reprisal and employees have the ability to make a choice as to who they want to represent them or if they want a representative. If you see those issues occurring, you want to take notes right away. You want to identify who your witnesses are so that you can easily create the offer of proof if you need to later on. You'll want to create a good offer of proof because the regional director will ultimately decide if you've presented enough evidence to get a hearing even on the issue of whether a new election should occur. They're relatively rare. I did one last year and I was told that in the Milwaukee region there had not been one for several years. So you want to make sure you have a good offer of proof. There's a hearing officer who will then hear the evidence, will make a decision. You can appeal that decision. I'm not going to go through all the appeal steps, but ultimately what happens is there is a ruling by somebody at the National Labor Relations Board as to whether or not the union should be certified or not certified. And if your objections are overruled, they will be certified. So I have on the next slide, the conduct that the board looks at. This gives you a good example of some of the things that you should not be doing as an employer if you don't want objections. It gives you an idea of some of the things that you should be taking notes about during the election if you may have to file objections. So what happens when the union is certified? Oh my gosh, now we have a union. I just told you about all of those bad things about having a union. What are you going to do? How can you run your business? Well, businesses run even with unions. It will be a little bit more difficult. But your main obligation at that point is that the union is the exclusive bargaining representative of the employees, and you have a duty to bargain with them. And we are sitting at a table today to sort of represent what that means. When you bargain with a union, essentially you will schedule dates with them to sit down and meet, and you will have your representatives and they'll have their representatives, and you have a discussion. Now, does that mean you have to agree to everything the union proposes? No. You may say no to everything, but you do have to have the discussion. And everything is on the table. If you've had benefits you're providing and you're like, I don't know why I'm providing this benefit, it really isn't helping me operationally, you can propose to not have that benefit. So everything is on the table. Ultimately, you will have what is considered your best, last, and final offer. And if the union accepts it, you'll have a contract. If they don't accept it, and there really is no more movement that can be made, you may be at what's called impasse. And that is not a black and white answer, unfortunately. It's a gray area. But if you believe you're at the point where there's no more movement that can be made, you can essentially say to the union, we're at impasse and we're implementing those terms and conditions that we told you were our last, best, and final offer. And then once you have the contract in place, eventually you'll have an expiration date. You don't have a contract which says in perpetuity, this is what we're agreeing to. It usually has a term of 2 to 5 years. And at the end of that contract, the process starts all over again. So what can you do to prepare when you're in that situation? There are a lot of things that you can do before those discussions even occur, which will help you. Obtaining financial data. If you've got benchmarking data about what's market in your area, that is a great tool. Looking at reports on how many other employers who are unionized are giving for their increases. Are they giving a 2% increase to employees? That's good data. Look at your handbook. What are your policies in your handbook? That's a good reference. One of the most valuable references is other contracts that the union has. If you can get copies of contracts they have with other employers, especially employers who are similar to you, that's going to be a good reference point for what you think you can get them to agree to as part of bargaining. And then feedback. If you know there was an issue from the campaign, what can you do to address that? Another important thing is looking at your leverage. Can you operate in a strike? Is this a situation where you can get replacement workers really easily, where you can have non-bargaining unit staff perform the work? The more leverage you have, the more difficult you can be in negotiations, or the more hard of bargaining you can engage in, because if you ultimately get to a situation where the employees walk out, you'll still be able to operate your business. Another point is looking at your union strength in key areas. If you have an operation where everything has to go through this one person and they're a union employee, that's going to be a potential problem, and the union has leverage because of that. And then finally, managing expectations. Having meetings with the union before you even engage in bargaining to let them know who you are. Having an opening statement to explain who you are. If it's a current relationship, having an opening statement to explain what's happened since the last contract can be helpful. Deciding who's on the bargaining committee. Usually you'll want to have somebody from finance involved, because they'll want to look at the data, the economics of it, and know, okay, this is what we can agree to, and this is how it's going to affect the company monetarily. An HR person who knows the employees and your policies, and then an operational person who knows the operations and how things you agree to might actually affect them. And then finally, you do have the ability to gather information. You will definitely get requests from the union. They will request everything under the sun, and there's very limited circumstances in which you can say no. You're going to get a request for your employee handbook, all your plans, all of your, SPDs, your 5500s. They're going to request a lot of information from you. As an employer, you also can request information from the union, and you want to think about things that might help you. So if you're at the table in particular and the union says, well, we don't do that anywhere else, maybe you should request the contracts they have at other locations to see if that's really true. So you do have that tool. So we are at the end of our time. I know that I have at least one question to answer. So why don't I do that from the webinar, and then we'll go around. I had a question actually on committees and whether or not there was any danger in having a committee that was composed of and individuals who could not be represented under the act. So that would be supervisors, having a committee where it was run by supervisors. I really think there's probably no danger there. The issue with committees and unionization and deterring unionization is employees who can be represented by a union. The board doesn't want you essentially creating your own labor organization so that employees feel like they don't need to go to a third party. If the employees on that committee are not individuals who can be represented by the union, that's not really a concern.
And then there's an excellent question here that came on solicitation that has to do with what happens when the union emails employees at their work email to advertise, solicit. How far can the employees go in banning this communication? This was a really hot issue about 5 to 10 years ago. I have not seen it as much of late. And Judy, I'm wondering if you have seen this in any of your union campaigns. That I know you had one quite recently.
Well, so first of all, you do have to provide email addresses now as part of the
Right.
quickie election rules. And they're personal email addresses, so normally it's not going to come through your email system where you can see what the communication is. Normally they send it to the personal email address of the individual. So that whether or not they come through your system, the National Labor Relations Act, the board held in Purple Communications that if an employee wants to solicit for purposes of union organization on your email system, they can, as long as it's not disrupting the operations and it's during non-working time. The board under Obama was trying to actually broaden that, and this is a situation where they were going to try to apply it to text messages and other types of communications. The board rescinded their memo that was looking to do that, and we've heard rumblings that they're trying to rescind the Purple Communications case, which would then prevent them, the employees, from actually sending the communications. I think you're less likely to have the union sending the communications to the employees' addresses internally because, one, they have to get a copy of the addresses, and two, under the current quickie election rules, they have the personal addresses, so there's really no reason to do that once they get the list of voters and their personal contact information.
Yeah, I agree with everything you just said there. As a practical matter, I have not found this one to come up all that often. It was a very hot issue. I think right around the time that the George Bush was president for 8 years before Barack Obama. But a lot of times the reason why it also doesn't come up is in the manufacturing setting, there aren't that many employees who have email addresses. And so even though it's a very interesting issue, and it could arise in certain situations, more like office settings or healthcare situations, it doesn't come up as much as you might think. But it's one to be aware of, and we'll have to see what the further developments on that are.
Mm-hmm. Do you want to go around the offices to see if there's any questions? Milwaukee, do you have any questions? John?
A non-union company, a manufacturing company buys a plant in a state.
Mm-hmm.
How common is it that plants try to organize the other plants?
That's a good question. I don't think it's necessarily common because normally the unions that are organizing are locals, so it's a local that's trying to organize. Does it never happen? I wouldn't say no. I think the closer you are, like if you are in the same state or the same geographical jurisdiction as the local, I think it's highly likely that they're going to organize. But if you're really that far apart, I think it's much less likely.
Yeah, and if you have a situation where a few situations where a non-union company wants to buy a unionized company, if the purchaser doesn't plan to hire all of the employees, it's going to interview employees separately. There can be situations in which you can actually avoid the unionization. I had one client that purchased 3 union facilities in September of a calendar year, got very lucky. By the end of the calendar year, in one form or another, the 3 facilities had all become non-union because they liked the new company. The company president came to each of the facilities. They painted each of the facilities, And so the union either abandoned the effort. So there are ways to work through those. Those can be very good opportunities for non-union companies to still remain non-union in their facilities.
Yeah, I would tell you if you're going to do that, contact us for sure, because there's some recent case law under the National Labor Relations Board where they are trying to make it much more difficult for a non-unionized company to purchase a unionized company and not have the union stay in place. Any other questions in Milwaukee? What about Chicago?
None here.
Indianapolis? Okay.
Okay.
Naples?
No, thank you.
Tampa? Not connected. Arizona, Phoenix? Nope. Any others? Minneapolis? Okay.
Thank you all.
Thank you.